Can you explain to me what designated facilities are and what the criteria are for involuntary admission? How is all that handled?
The only hospitals or other facilities that can admit people on an involuntary basis for psychiatric treatment in British Columbia are three types. There is a psychiatric unit, observation unit, and provincial mental health facility. Psychiatric units are usually the larger hospitals. Small hospitals may be designated as observation units, and provincial mental health facilities accept and treat people on an ongoing basis, on a chronic basis. So it is usually more of a residential type of placement in those facilities. It is only those facilities, either one of those three, that can accept involuntary patients. The designations are done by the minister on the recommendation from staff in the Ministry of Health, and that's usually at the request of a health authority. Hospitals that are not designated and care facilities, which are licensed under the Community Care and Assisted Living Act, they are not allowed to admit patients on an involuntary basis under the Mental Health Act. So in those facilities, those hospitals that are not designated under the Mental Health Act and facilities that are licensed under the Community Care and Assisted Living Act, they can only have people on their premises and keep them, often against their wishes, and treat them if they are placed on extended leave from one of the designated facilities. Now, the procedure is that either a person is examined by a doctor, it can only be a doctor, in the community, perhaps in a doctor's office, or maybe in the person's home, or perhaps in a facility, and the examination shows, in the view of the physician, that the person is certifiable under the Act. Then, on the basis of the certificate that the doctor can then sign, the person can be taken to hospital against the person's will. The certificate is referred to as medical certificate. Strictly speaking, it's called a Form 4 under the Mental Health Act, but since times immemorial, that form has been called the PINK. So in practice, people often talk about, has the person been pinked? That means, is there one certificate signed by a physician that can then be used to get the person into hospital? Once the person has arrived in the hospital, then the hospital has 48 hours to have another doctor do another examination. And if such a second Form 4 is not signed, then the person must be discharged. If that form is signed, then the person becomes involuntary for up to 1 month.
So what would happen if a person arrives without a PINK?
Well, a person can arrive at the hospital without having been examined and without a Form 4 having been done, either because they recognize they have a problem, family, friends recognize that the person has a problem and take the person to hospital, or the police may have apprehended the person and then taken the person to hospital. Once the individual is seen by a doctor, and a doctor again has signed the Form 4, then they become an involuntary patient, and from that moment on, the hospital has 48 hours to get the second certificate done. The criteria that the physician must follow are very broad in BC, much broader than in other provinces. First of all, the person must be suffering from a mental disorder, and generally speaking, the courts have left that entirely up to the doctors. In other words, In BC, there is no specific definition under the Mental Health Act of what a mental disorder is, nor have the courts tried to tell doctors what a mental disorder is or not. The only exception is one case at Riverview Hospital about 20 odd years ago now, where the issue was whether a mental disorder arising out of an organic cause was a mental disorder under the Mental Health Act for which a person can be treated under the Mental Health Act. And the court said yes. So if a person has some kind of brain injury, some kind of brain illness that is organic in origin under BC law, because of that decision by the BC Supreme Court, that is considered to be a mental disorder for which the person can be admitted and treated in a BC designated facility. So first of all, the person must have a mental disorder, and in the opinion of the physician, it must be a serious mental disorder. The Act uses some archaic language. It talks about is the person able or unable to associate with others, or can they react appropriately to their environment? So indicating the severity of the mental disorder. So that's the first criterion, a serious mental disorder. Secondly, and this is again very different in BC, in order for a person to be able to be certified and to be admitted and treated on an involuntary basis, that mental disorder must require a treatment, psychiatric treatment, and there must be treatment available. And it's very important to remember that if there is no treatment available, if the person is simply going to be secluded, that is not sufficient in BC for a person to be admitted. Treatment always must follow, and that's different in other provinces, for example, Ontario. And it must be psychiatric treatment. In other words, if a person is incapable and refuses to consent to surgery, the Mental Health Act cannot be used to get that person made to be involuntary and then have to undergo the surgery. That is not possible under the BC Mental Health Act. Thirdly, and that's the most complex one, the third criterion is that the person's condition must be such that either the person themselves or others need to be protected. So the way the Act refers to that is that the person needs care, supervision, and control for their own protection or for the protection of others. The government added about 15 or so years ago a further criterion to the requirement for care, supervision, and control, and that has to do with deterioration. So if a person is mentally or physically deteriorating in such a way that that needs to be stopped, then the person can be certified despite the fact that they haven't reached the protection criterion yet. So if a person starts to decompensate, a doctor says, well, this person is on their way to getting the condition in which they need protection or others need protection from them, then the physician can already certify at that point while the person is still deteriorating. And finally, the fourth criterion is that the person must not be involuntarily admitted if they can be admitted voluntarily. In other words, if the person says, yes, I'm prepared to be treated and I give consent to the treatment that you prescribe, then the person must not be involuntarily admitted. Now, that term protection has been and was for a very long time and continues to be, unfortunately, somewhat of an issue because of the fact that in the 80s, the term protection was not well understood. And in the early 90s, a few advocacy groups took the BC government to court and asked the court to declare that the criteria that we've just discussed in BC are not constitutional. In other words, that they do not satisfy the test under the Canadian Charter of Rights and Freedoms. In particular, the test under Section 7, which says that government action, including legislation, is only justified if the rights of every individual in Canada under Section 7 are satisfied. The section says that everyone has the right to life, liberty, and security of the person, and the right not to be deprived of those rights, except in accordance with the principles of fundamental justice. And these groups, and they found a plaintiff, a patient by the name of Mr. McCorkell, went to court, and they argued for Mr. McCorkell that he and others who were involuntarily detained and treated were treated not in accordance with Section 7 of the Canadian Charter of Rights and Freedoms. They argued that the word protection was overly broad, and that was the reason that many more people can be involuntarily admitted and treated in BC than is justified under the Constitution. So this was a very, very important case, a pivotal case. The BC Supreme Court in the end decided that the criteria, the test under Section 7 was justified, was satisfied, that clearly when a person is admitted to hospital and treated in that hospital against their will, that engages the person's right to liberty and security of the person. But the Constitution says that can be done. A person can be deprived of the liberty and security of the person, but only in accordance with the principles of fundamental justice. The court said the criteria in the BC Act do satisfy that test of Section 7, and totally contrary to the expectations of most people involved in the court proceedings. The court proceeded to say what protection meant, and the court vastly expanded the definition of protection. So rather than doing what the two advocacy groups wanted, namely to restrict the meaning of protection, the court expanded it. The court said, advocacy groups want it to be restricted to physical harm only, so that a person can only be admitted if they're likely to cause physical harm to themselves or others. But the court said that's only the first one of the various grounds, the various possibilities that together make up the meaning of the word protection. So the court said in addition to physical harm, if the person presents or is likely to present financial harm or vocational harm having to do with how a person earns their living, including professional practice or a business. And in addition to that, the court said family harm and even social harm. The court did not define what social harm means. But together with all the other ones, it's clear that rather than restricting the meaning of the word protection, the court in McCorkell very much expanded it.
So this is going to be very different for physicians that are trained in other provinces or other countries. So can you summarize what would be particularly different in practice for those physicians?
For most physicians coming from other jurisdictions, where by and large, although these things have been changing, even in provinces like Ontario and Alberta, most physicians that come from other jurisdictions are used to the dangerousness criterion. In other words, they think that a person can only be involuntarily admitted, can only be certified, admitted, and treated against their will if the person is likely to be physically dangerous to themselves or to others. It's very different in BC. As I mentioned, the other possibilities of harm can also justify a person to be certified. Now, very often it's not just one risk that the person is running or others are running. Very often it's physical risk and perhaps family harm. It may be physical and financial. Very often financial and vocational go together. But each one of them is by itself sufficient reason for a physician to consider that the person needs protection or that others need protection from that person, and then to certify the person and have the person involuntarily admitted.
So if a facility is not designated under the Mental Health Act and there's an emergency, what can they do to help that person?
Facilities that are not designated
yeah.
under the Mental Health Act, and they end up with a person in their facility, in their hospital, who is certified, then they should transfer that person as soon as is reasonably possible. I am very often asked, how much lead time is there? How much of a grace period? And I always have to say to people, there isn't one. So if there ever were to be a lawsuit, and we're lucky in BC, we don't get these lawsuits very often, but we've had a few, then the hospital would have to be able to show that they were aware that they were not treating the person in accordance with the Mental Health Act, which they can't because they're not designated under the Mental Health Act, and that they've taken all reasonable steps to get the person transported to a designated facility as soon as possible. There are two ways that a person can end up in a non-designated hospital. The person can, again, as I mentioned earlier, go there on their own, be brought there by family or friends. But frequently what happens is that the police can apprehend a person, and they're entitled to take a person if they feel that the person needs examination by a physician. They can take the person to a physician wherever they can find a physician. They could even take a person to a doctor's office, which I don't think they've ever done. But if they are close to a non-designated hospital, it's understandable that they take the person there. And then any physician there would have to examine. And if that physician then signs a Form 4, making the person involuntary, then that hospital, which is not designated, has a patient in the hospital who shouldn't be there because they're involuntary. So then there is this duty on the hospital to transport the person as soon as possible, and a duty on the closest designated facility to accept. And unfortunately, that isn't always handled very well.
Interesting. So the subject of examination has been clarified. What exactly is an examination? Can you speak some about that?
The BC Mental Health Act doesn't contain a definition of examination. And there's often been speculation around how that should be handled. What is an examination? Is it always necessary to interview the person? I'm aware of situations where physicians have certified people while talking to them through a closed door. So it wasn't clear as to what an examination meant, but it was generally assumed that the physician would have to speak, be able to ask questions of the person, and to be able to get answers from that person. A few years ago, the Court of Appeal had the occasion to talk about that because in one of the hospitals in Vancouver, a person was restrained and was medicated without being properly certified. And, or at least the argument was that a person had not been properly examined and certified on the basis of that examination. The Court of Appeal said, somewhat surprisingly, that they seemed to indicate that an interview, the doctor talking with the patient, wasn't always necessary. In fact, they started by saying if there is sufficient information from family, from friends, from the police, from a charge in the hospital, if the person has been admitted and treated in that hospital before, any kind of information about the patient, about that person, that would lead the doctor to conclude that the criteria we talked about earlier are satisfied, then that would be sufficient. And it seems almost as an afterthought, the court said, oh, and if possible and necessary, then the physician should examine the person as well, in the sense, I shouldn't have used the word examine actually, the court said there should be an interview then, which one has to see in the overall context. That is what the Court of Appeal said. But I don't think they were thinking at the time of other legislation, the Freedom of Information and Protection of Privacy Act, which says that information always has to be obtained from the person who the information is about first. In other words, it should be normative always to talk with the patient and to find out from the patient what they have to say. And then only secondarily, the charge, the family, and others can be consulted. But they made it very clear that it isn't absolutely essential in all cases that there be a personal interview. That avoids the dilemma that exists in some other provinces, where a patient has a right, or a person who is being examined under the Mental Health Act has a right to remain silent. And if the person doesn't answer any questions, then the person likely cannot be certified. So the court was at pains to ensure that that would never happen, or that there would be a situation where a person might flee and be potentially harmful to themselves or others, might run out of hospital onto Barrage Street in Vancouver and run under a vehicle. So the court said in those situations, despite the fact that the doctor hasn't been able to talk yet with the person, if the doctor has enough other information, then the doctor can ask the police to go after that person and bring them back, despite the fact that there has been no examination in terms of a possible interview, questions and answers having taken place.
Does the Freedom of Information and Protection of Privacy Act allow sharing information with family members? And under what conditions is that allowed?
The whole issue of the Freedom of Information and Protection of Privacy Act and how it interacts with the Mental Health Act is a fraught one. We've had the Freedom of Information Protection and Privacy Act for about 23 years now, and right from the start there has been this dilemma with people saying people have the right to privacy and confidentiality, and that should never be interfered with, even if the person is potentially harmful to themselves or to others. That was always too strong a position to take in any event. There is a provision in the Freedom of Information and Protection of Privacy Act that makes clear that information that is collected, that is obtained about a person, can also be disclosed, can also be shared for the same purpose as the information was obtained. The information was obtained, of course, for the treatment of this person so that they would not be harmful to themselves or to others. So if that information needs to be disclosed to keep the person safe in the community or to keep others safe in the community, that can be disclosed. And that is unfortunately something that isn't always acknowledged or understood. In other words, if family members, for example, are closely involved with the aftercare, the post-hospital care of the patients, then, and that can be, of course, because this young person or older person, for that matter, may live at home or with another family member, or they may live in a facility or a mental health boarding home. Any information that the people caring for this individual need to know in order to safeguard that person, that person's own safety, but also their own safety and the safety of family and other people in the facility or home where the person is being taken care of. In other words, any information that is necessary for the follow-up care providers to know, regardless of whether these are paid care providers or whether these are family members or friends, that information can be disclosed. In addition, there is a specific provision in the Freedom of Information and Protection of Privacy Act that says that any information may be disclosed. There's a specific procedure for that. It's the head of the health authority, that is the CEO, or a person to whom the CEO has delegated that authority. The CEO or the delegate can make a decision that certain information needs to be disclosed in order to prevent harm happening to a particular person or persons. In the States, this is called the Tarasoff exception. In the States, there is actually a duty if a physician or a nurse knows about the possibility that a patient who is being discharged or a person who should be in hospital but isn't, likely being dangerous to somebody else, then in the United States there's a duty. In Canada, there is no duty, but there is an ability to do so. And my position is that if you are allowed to disclose information to keep someone from harm, then you should, on ethical grounds.
Can you speak to considerations around discharge, particularly when there is a risk that the person, as a result of their mental disorder, won't follow the treatment plan and you'd like to minimize the possibility that they'll again be detained under the Act?
There are three possibilities, three types of professionals or bodies that may discharge. Most discharges, of course, happen because the physician decides that the person no longer needs to be in hospital, or this can also happen when the person is on extended leave in the community and the physician decides the person no longer needs to be involuntary and be subject to conditions of the leave. So that's the great majority of cases. Other discharges may happen by the review panel, a panel of the Mental Health Review Board, or the court. The latter is the least likely because, unlike in other provinces, very few of these cases end up in court. So the great majority of discharges happen by doctors and a small percentage compared to physicians by review panels. The Act was changed about 15 years ago to ensure that whoever makes the decision that this person can now be discharged, no longer needs to be involuntary, addresses their mind to the history of this person. Has this person been in hospital before? Have they been discharged before? What has been the pattern? Did they immediately on leaving the hospital, did they stop taking their medication? Did that mean that they were back in hospital within a few days or a week? So that needs to be looked at. So the physician and the review panel and, unlikely event, the court all need to look at, when they make the decision to discharge, what is likely going to be the result of this. Is there a likelihood that then the person will stop taking their medication, will stop seeing their doctor, and they will then have to be readmitted? The situation is not only that the physician must be satisfied that the person doesn't come to immediate harm, but the physician also, or the review panel, in case of a review panel making that decision, must look to, in the reasonable, foreseeable future, is this person likely going to backslide, go off their medication, refuse to see their doctor, and will then have to be readmitted. And particularly if there's a history of that, then the physician and the review panel, according to the Mental Health Act, should say, no, we're going to decide that you need to stay a bit longer in hospital until the point is reached where we do not think that you will likely need to be readmitted in a foreseeably short time.
So that leads me into the subject of leaves and extended leaves from hospital. Can you explain to me a bit about how that works and how that can be used as an option?
Frequently people ask about community treatment orders. There are about half a dozen provinces that have that. British Columbia doesn't know that concept of CTO, community treatment order. Our extended leave, or the way the Act calls it, simply leave, takes the place of the community treatment order, which means that rather than a person being ordered to take treatment in the community, they always have to be in hospital first. This has been considered by the government, by the Ministry of Health, on a number of occasions. Should we have the possibility of community treatment order? And it was always in the end decided it's better for the person to be in hospital, even if only for a relatively short time. But it has been in the Act for many, many years that a person can be placed on leave by the director or a physician authorized by the director of the particular facility. All the Act says is that the director or the physician must be of the opinion that treatment in the community would benefit the person. And by implication, it would of course mean that they consider that the person no longer needs to be an inpatient in the hospital. Very importantly, this is sometimes referred to as conditional leave. And the typical conditions are the person must continue to take their medication. They must continue to see their doctor, psychiatrist, or GP at the set times, must engage with their community mental health worker, their caseworker, if they come to check up. And this, oddly enough, has become much more prominent of late. One condition is also that a person must live in a particular environment. There is some pushback. Some people believe that that unjustifiably infringes on a person's right to live where they please. However, the concern is that the environment has to be a therapeutic one. In other words, we've seen patients go out on leave and end up with friends who ply them with alcohol or drugs, and then in another day or two they're back in the hospital. So if, as far as the director or the physician can determine the environment where the person wants to live, the address where they want to go, is not conducive to them being able to continue to live safely in the community, then the director or authorized physician can say, no, I'm not going to allow you to live at that particular house or to move there. You must stay in the safe environment that I believe will be conducive to you being able to live safely in the community.
So a leave, I'm imagining that there are restrictions on how long a leave can go on, or a regular review process. Is that correct? Is that similar to the process where a person might be reviewed if they were physically in a hospital?
There is no specific process to monitor and review extended leave that's different from the same process that happens within the hospital. In other words, regardless of whether the person is an inpatient or they're out on leave, extended leave, there have to be regular reviews. So both in the hospital and in the community, at the end of the first 1 month period, before that period is up, a physician must re-examine the person and conclude that they still satisfy, their condition still satisfies the criteria under the Mental Health Act for involuntary admission and treatment. At the end of that second 1 month period, then there has to be another review, and then the person can continue to be involuntary for 3 months. At the end of the 5th month, again, there has to be a review before that 5th month period is up, and then the person can be made involuntary. If they're renewed, they're made involuntary for 6 months. And again, the 1 month, 3 month, 6 months happens both in hospital and in the community. So the person must be seen, if they're living in the community, at the end of each of those periods. However, in the meantime, of course, as I mentioned previously, there will be contact. They will have to see their physician at regular intervals. They will have to see their caseworker. And if at any point it appears that a person isn't doing so well, they are going off their medication, they refuse to see their doctor, they refuse to talk to a community mental health worker, then they can be recalled. And the recall is usually done by a physician in the community. Because when the person is placed on extended leave, it's done again by a specific form, a Form 20, and the patient is asked to sign the form, but if they refuse to sign, that doesn't invalidate the leave. And that form goes to a physician who must have been approached before by the director or the hospital-based physician as to whether this physician will take on the care of this patient. And then typically, not always, but typically that physician then becomes not only the attending physician who continues to treat, but also makes decisions about whether any of the conditions must be changed, or whether the person needs to be recalled to hospital because they're no longer thriving in the community.
In regards to ending or reviewing an extended leave or a conditional leave, I'm imagining that the same discharge considerations come into effect, whether, a person might be in the community and they may be thriving, but if the doctor believes that if they're no longer on conditional leave that they will stop taking their medication and they will need to be readmitted, that they have some duty to keep that leave going, even if the person's doing great.
Absolutely. All the requirements of the Mental Health Act apply equally to a patient who is being treated in hospital as they do to the same patient being in the community. I've already talked about the reviews, but in terms of discharge considerations, the very same principles apply as do in the hospital, so that a person, when the physician decides that a person no longer needs to be on leave, or the review panel decides that the person is no longer certifiable, they must apply the same test that I talked about earlier. Is the person likely to get into trouble when they are no longer involuntary? Are they likely then, because they know they're no longer on extended leave, are they likely then to stop taking their medication? So the same discharge considerations apply.
Can you tell me about, can you describe the police authority to take a person into custody and to a physician for an examination, and just focus on whatever the key issues that a physician might need to understand about that?
The police have the authority, as they do everywhere in Canada, and the conditions for that are identical across the country. If the police believe that a person apparently suffers from a mental disorder and is likely to be dangerous to their own safety or that of others, then the police can take that person, can apprehend that person and take the person to a physician. Now, we often restrict the meaning of the term safety to this person potentially being violent, but that need not be the case. Depending on the weather conditions, depending on where the person lives in the province, if they live in the north, and the temperatures are very, very frigid. There's a snowstorm, and because of their mental disorder, they don't realize that they need shelter, then the police can take them in to a physician. The problems that have arisen over the last decade or so is that sometimes the police believe that they need to have some warrants, and they do not. The Act is very clear that it's the authority of the police to decide is there likely or apparently a mental disorder involved, is the person likely to be dangerous to their own safety or others. No court, no warrants are necessary at that point, and they can simply take the person to a physician, and then when the physician examines and certifies, then the person is an involuntary patient under the Mental Health Act.
Great, thank you. There's one more, please. Consent to treatment. You wanted me to ask you about that.
I'm wondering now whether I should also say something about the courts.
Okay.
Because
what else would you like to tell me?
the third possibility, and I always ask my students this on exams, there are 3 procedures under which a person can end up in hospital under the Mental Health Act against their will. Most of the time, of course, it's possible to persuade a person to go to hospital or to see their doctor and then to be certified. Sometimes the police are necessary. There's no other way of getting the person there. But if the police never has the possibility of seeing the person, now I did not mention earlier, but the police are also entitled to rely on information they receive from others. That is frequently a problem, that the police say, well, you're telling me this, you as the wife or the mom or the brother tell me this, but the person seems to be fine to me. The problem, of course, is that very often the person becomes quiet as soon as there is a police officer in the room or the environment where they are. So the police actually can rely on collateral information alone, but that can frequently be a problem, that the police doesn't feel that they can do that, that they feel that they should be able to verify for themselves. So if there is that problem, the police hasn't been able to talk with the person, they're not quite sure that the information they're getting is trustworthy, or perhaps sadly it has happened that the police repeatedly take the person to hospital, and then the physician on duty says, no, there's no mental disorder here, and the police have to let the person go. In any one of those situations, anyone, that's usually a family member or a friend, but it can be a mental health worker, can go to provincial courts, can ask to speak with a provincial court judge, or if there's no judge available, with a justice of the peace, and can simply tell that person the story of them having tried to get the person examined by a doctor, and for whatever reason that was not possible. If the judge or the justice of the peace says, well, yes, that sounds like you've done the very best possible, and that hasn't worked. The person has resisted all efforts for you to take them to a physician or to a hospital, and every time the police is called, the person takes off and cannot be found. In those situations, the judge or the justice of the peace can issue a warrant, it's called Form 10, and then the police must find the person, whatever the person is, and take the person to a hospital. And then there has to be a formal period that the person is in hospital. Just by the court having said the person must be examined, then the hospital has a 48-hour window to get two physicians to examine the person. So even if there has been no examination yet, the person, because of the court order, has to stay in the hospital for 48 hours. And some family members have found that very, very useful. Consent is a very troublesome issue. In BC, it's very controversial because we are virtually the only province where consent is not necessary. Or rather, it's more complicated than that. There is one other province, Saskatchewan, where there is no consent necessary at all. In BC, there is a consent form. It's called Form 5. And I'm very happy to say that over the last few years, I've become aware that physicians and nurses in hospitals have become much more conscientious about completing the Form 5. The reason that's so important is that the courts have said over the last several years that if you don't have that Form 5, you can't treat. So then you've got a patient who's in hospital that you cannot treat, except in an emergency, of course. So what is so controversial about the Form 5? Well, it seems to give the patient the ability to consent to their own treatment. In fact, it does. But if the patient is found to be incapable, and refusal is tantamount, is the same as incapable, then the director or a delegate of the director will sign. And that is frequently attacked on the basis of, frequently criticized, advocates saying that does not comply with the Canadian Charter of Rights and Freedoms. There should be a genuine substitute decision maker involved, such as a family member. And here we're talking about a person who gives consent on behalf of the patient who's not exactly at arm's length. It's either the director, or it is another doctor, or it's a nurse working in the hospital. So that remains a controversial issue. We can't resolve that, of course. Either the government will have to decide to make a change in that process, or the court will have to decide that the current practice is unconstitutional. But in the meantime, what is very important is that Form 5 should be signed either by the patient, if the patient recognizes that this particular treatment is conducive, is likely to lead them being able to leave the hospital much more quickly than would otherwise be the case, or if the patient is not prepared to consent or cannot consent, then the physician signifies that the person is incapable, and then the director or a delegate of the director will sign the form instead.
So what are the issues around notice to relatives? I'm assuming this is around a person being admitted or a person being discharged.
For the past 15 or so years, the Mental Health Act has required that the patient must be informed of their rights, and that a close relative or friend also be advised of the fact that they are in hospital and they have certain rights. So there is a form that's called Form 13 that must be given to the patient, regardless of whether or not the patient understands. If the patient is likely to understand, then the nurse or social worker reads out the top part, which is bolded, so the patient knows where they are, that they are an involuntary patient, that they have the right to contact a lawyer or an advocate, that they have a right to apply for a review panel hearing, for a second opinion about the treatment that they're getting, and so on. In addition to that, the family member or friend designated by the patient also receives notification that the person is there and that they have certain rights. This is frequently misunderstood. I often get calls from nurses who say, well, this patient doesn't want their family to know. And clearly we cannot do that. We cannot notify the family because that's the patient's right to privacy and confidentiality. No, the Mental Health Act overrides the right of privacy and confidentiality. So someone needs to be notified. The patient has a right to indicate which family member or friend or caregiver they want to know. So if they don't want their mom to know, but their cousin, they can indicate the cousin. But somebody gets that form to say this person is now hospitalized at such and such a facility, and these are the rights that they have. Because unlike most other provinces, we're frequently criticized that BC doesn't give patients enough rights. But one right that's quite unique is that anybody can exercise the rights of the patient on the patient's behalf. So a family member or a friend can actually request a review panel hearing if the patient isn't capable of doing so.
Does the notice to relatives apply in the case of discharge?
There are various notices. So not only does a relative or a friend need to be notified that the person is in hospital once the person is discharged, or there is an application by the patient or someone on the patient's behalf for a review panel hearing, as a result of which the patient may be discharged, then that family member or close friend must again be notified that that's the case.